Parties entered into a franchise agreement for operating a restaurant. One party sued the other, avoiding the agreement's arbitration provision, but the court served the plaintiff a disappointing decision about the Federal Arbitration Act in Doctors Associates Incorporated versus Casarotto. Doctors Associates Incorporated, or DAI, was a franchisor of Subway restaurants. Paul Casarotto and DAI entered into a franchise agreement so Casarotto could operate a Subway in Montana. Page 9 of the agreement stated, quote, "Any controversy or claim arising out of or relating to this contract or the breach thereof shall be settled by arbitration," unquote. In a Montana state court, Casarotto brought tort and contract claims against DAI and its agent, Nick Lombardi, arising out of the franchise agreement. DAI wanted arbitration, so the trial court stayed the case. But the Montana Supreme Court held that the agreement's arbitration provision wasn't enforceable. The court cited a Montana statute that required contract provisions requiring arbitration to be underlined and in capital letters on the contract's first page. According to the court, the arbitration provision in the franchise agreement wasn't enforceable because it was on page 9 and wasn't in the correct typeface. The court reasoned that the Montana law didn't offend the Federal Arbitration Act, which usually requires enforcement of arbitration agreements. The Montana statute only required notice of arbitration, so it didn't undermine the goals or policies of the Act. The United States Supreme Court granted cert.